You're watching the legal breakdown. So, Glenn, this is the first big update we've had in Trump's DC trial in what feels like weeks or months now. Mark Meadows will receive immunity in exchange for his testimony against Donald Trump. Does him getting immunity suggest that his testimony will be that much more incriminating against Trump here?
You know, Brian, this is a big development, but it's not necessarily an especially good development. Here's why I say that. When somebody like Mark Meadows, who it sure looks like committed all kinds of crimes in concert with Donald Trump, perhaps at the direction of Donald Trump, certainly for the benefit of Donald Trump. When the prosecutors want to extract evidence out of a guy like Mark Meadows, frankly, our least favorite way to do it is by giving Mark Meadows immunity. Why is that? When you confer immunity on somebody, you're basically giving them a free pass for their crimes. Now, sometimes you don't have enough evidence to charge them with crimes, but you have to give them immunity because they do have some lingering Fifth Amendment right against self-incrimination. But rather than charge them because you don't have enough, you grant them immunity, you put them in the grand jury, and you compel them to testify about what they know, divulge all of the incriminating information they have about others. In this case, it's about Donald Trump. But here's the problem with immunity. If you never hold Mark Meadows accountable for his crimes, instead you give him immunity, you extract from him all of the incriminating information he has about Donald Trump, and then you have to put Mark Meadows on the witness stand in a future trial against Donald Trump, his credibility will be suspect beyond, the fact that Mark Meadows' credibility is already suspect, because what's going to happen is the defense is going to cross-examine him on, wait a minute, you engaged in misconduct. You never had to take responsibility for your misconduct. In fact, the prosecutors gave you a pass, and now you want the jury to believe you when you start testifying about the crimes of others. You know what, Mr. Meadows? You will say anything these prosecutors want you to say about these alleged crimes of Donald Trump to stay out of prison because you were never charged with anything. It compromises a witness's credibility when you give them immunity and you don't hold them accountable for their crimes. That's why the preferred method of extracting incriminating evidence out of a witness like Mark Meadows is to charge him with his crimes. Remember how he was forever burning documents in his fireplace after important meetings? I don't think that was to generate warmth. I mean, that was obviously nefarious. And that is just one of 100 examples we've heard of Mark Meadows being up to no good. So it would have been the far better practice to make him plead guilty, to negotiate a plea agreement that required him to, one, take responsibility for his own crimes, and then two, testify truthfully about the crimes of others. So this immunity has diminished the value of the evidence he's given, and it's hurt Mark Meadows' credibility even more.
Well, to that exact point, isn't he too big of a fish to be getting immunity here? Like, doesn't there come a point where it is more of a miscarriage of justice to keep letting very culpable, high-ranking people skate by, even if it is in service of getting Donald Trump?
That's the perfect question and the perfect point. Because the chief of staff to the president of the United States, right? That's about as close as you get to POTUS. If
Yeah.
you are involved in democracy busting crimes, you have to be held accountable because Mark Meadows, in a very real sense, was responsible for protecting our nation, protecting the Constitution, protecting our democracy. And instead, he was in league with Donald Trump trying to overturn the results of a presidential election against the express will of the American voters. That's not the kind of guy you give immunity to. That's the kind of guy you go hard after. And if he's unwilling to plead guilty to his crimes, you take him to trial. You sit him shoulder to shoulder with Donald Trump as a co-defendant in the federal prosecution in Washington, D.C. You're absolutely right, Brian. He is too big a fish to let go. Now, let me hasten to add, there are different kinds of immunity and different levels of immunity. There's what's called use immunity, which simply says we're going to compel you to testify, but nothing you say in the grand jury can be used against you because we're giving you immunity. Then there's transactional immunity. That says we're giving you immunity and you can never be prosecuted for anything involving the subject matter of your testimony. Two different things. So you can give somebody use immunity and then still prosecute them later only if you can prove that nothing they said under that grant of immunity made its way back into the investigation or the prosecution of a Mark Meadows, because that would violate the immunity agreement. Let me throw out an historic reference. If you remember Oliver North in the Iran-Contra affair, he committed all kinds of crimes and he was indicted, prosecuted, convicted, and imprisoned. But Congress had granted him immunity and forced him to testify. And when his conviction went up on appeal, you know what happened? The appellate court busted it. They reversed it because they said, hey, you compelled his testimony. He said things that incriminated him under the protection of that grant of immunity. And we're not satisfied that none of that evidence crept in to the investigation or his criminal prosecution. That highlights the danger of granting limited use immunity to a guy like Mark Meadows if you intend to prosecute him in the future.
Okay. Now, what do you expect Meadows might be able to give prosecutors that would be that valuable that they let him escape accountability here?
Listen, he was with the president in the run-up to January 6th and on January 6th. And we've heard lots of evidence and information and even testimony during the January 6th House Select Committee hearings from people like Cassidy Hutchinson, who said, you know, Mark Meadows would come out of the Oval Office kind of white as a ghost. I may be taking liberties with exactly how Cassidy Hutchinson phrased her testimony, but, you know, she would say, you've got to tell the president to stop the attack, call off the attack. And Mark Meadows would say, you know, Cass, he doesn't think they're doing anything wrong at the Capitol. He thinks Mike Pence deserves it, deserves to be hung. Well, here's the thing. Out of Cassidy Hutchinson's mouth, that's hearsay. That's not admissible testimony against Donald Trump because it's coming from Mark Meadows as the intermediary. But if Mark Meadows came to the table as a witness and testified, Donald Trump told me that his supporters were right to be attacking the Capitol, and they weren't wrong when they said Mike Pence should be hung. That is directly admissible evidence against Donald Trump because the witness heard it come out of his mouth. Cassidy Hutchinson heard it come out of Mark Meadows' mouth, what Donald Trump was saying. Quintessential hearsay, not admissible. So yes, he may have some sharply and deeply incriminating evidence to provide against Donald Trump. Maybe that is why Jack Smith decided to grant him that limited use immunity, assuming that's the kind of immunity he granted, and extract that evidence from him. And, you know, he may still be retaining the right to prosecute Meadows in the future. Only time will tell.
Okay, just a quick question on this. Will we eventually or ever find out what Meadows was able to give prosecutors if they use something in the case against Donald Trump?
I think so. Certainly, if Meadows is called as a witness,
okay,
he will be largely regurgitating what he said under that grant of immunity before the grand jury. So we will hear it. I suspect one way or another, we're going to learn why he was granted immunity, what he said, and obviously whether he will still be prosecuted for his crimes.
Okay. Now, on the issue of further prosecution for Mark Meadows, can you talk about the implications on the Fulton County case? Can Meadows' testimony be used against him in Fulton County, Georgia, even if it is covered by an immunity deal in D.C.?
That's a great question, and I don't know that there is a completely accurate answer, because here's why I say that. You're dealing with two different governments, two different jurisdictions, two different sovereigns, and we all know there's the federal government, there's the state government, and the state government retains a whole lot of power and independence from the federal government. This is federal immunity. So Mark Meadows was compelled to go into the federal grand jury and testify under this grant of immunity. So Jack Smith has that transcript, that testimony of Mark Meadows that was provided under that grant of immunity. And technically speaking, there may be no prohibition from Jack Smith taking that transcript and giving it to Fani Willis for her to use in her RICO prosecution in Georgia because they're different jurisdictions. But I don't think that's going to happen. I think that would violate the spirit of the immunity, if not the letter of the immunity, because once you compel a witness to testify and provide information that would incriminate him under the protection of a grant of immunity, I think the courts would rule that not only is the federal government bound by that agreement, but first, virtually every other jurisdiction, every other court, every other prosecutor is going to be bound by that agreement, by that immunity conferred by the federal government. So I don't think Fani Willis or any other jurisdiction will get to exploit whatever it is Mark Meadows said in the federal grand jury.
Okay, and finally, just a quick question on the technical definitions here. Can you speak on the distinction between immunity and a plea deal?
Yeah. So a plea deal is not really a kind of immunity, but it is a way to sort of limit your criminal liability, your criminal exposure. When it comes to a plea agreement with cooperation, what the prosecutors do is they will offer a defendant a package deal. They'll say, listen, we'll reduce some of the charges you have to plead guilty to. Maybe we will cap your potential sentence to prison time if you plead guilty and you promise to testify truthfully against and about anybody else, for whom you may have incriminating information. That's not immunity. That's a way to limit one's liability by striking a contractual agreement with the prosecutors to plead guilty to something and agree to testify truthfully against others in exchange for a benefit, reduced charges, or maybe a cap on your sentence, maybe even probation, as we're seeing in some of the guilty pleas with cooperation down in the Georgia RICO case. Immunity, you are never charged with your crimes. Immunity is just a court order saying you could otherwise refuse to testify because your truthful testimony would incriminate you, but we're going to extinguish your Fifth Amendment right under the Constitution by granting you immunity and saying it can't be used against you. But that's kind of the difference between a plea agreement with cooperation and a grant of immunity.
But wouldn't the immunity be conditional upon them actually going ahead and testifying? Like, can't they be forced to testify if they're being given immunity?
If they're so when we apply to a court for immunity, it's actually called a compulsion order. We file a motion with the court after we get the approval from the Department of Justice. There's a whole office that decides whether immunity requests should be granted or not. Once we get the approval from DOJ, then we apply to the court for a compulsion order, and the chief judge will issue a compulsion order directing the person, you are hereby being compelled, lawfully compelled, to testify before the grand jury. And if you don't, you could be held in contempt of this compulsion order being issued by the court. So the person has to go in and testify. And here's the thing, immunity is not a license to lie. So you go in, you testify, nothing you say can be used against you unless you lie. Because if you lie, you're now committing new crimes after the immunity was granted to you that could be perjury, it could be obstruction of justice, it could even be accessory after the fact if the lies you told in the grand jury under that immunity order tended to help somebody else get away with their crimes. So it's not a license to lie, but it is a requirement to go in and testify.
Okay, got it. All right, well, with that said, obviously a lot to say on top of, especially on the Mark Meadows of it all and this DC case. So if you want to follow along with everything that's happening right now, please make sure to subscribe. The links are right here on the screen. I'm Brian Tyler Cohen.
I'm Glenn Kirshner.
You're watching The Legal Breakdown.